Welcome to Health System CIO's Partner Perspective interview series. I'm Anthony Guerra, founder and editor-in-chief. Today we're talking with Teresa Burns, Director of Privacy Operations and Privacy Officer with Protenus. Teresa, thanks for joining me today.
Thank you for having me. I appreciate the opportunity to be here.
Very good, thank you. Okay, you want to start off by telling me a little bit about your organization and your role?
Okay, I am the Chief Privacy Officer for Protenus. Protenus it is a compliance data analytics company that works with large and small health systems and hospitals to monitor accesses to patient records, so it's privacy monitoring. And also we have a drug diversion product where we assist hospitals with monitoring the flow of regulated drugs through their system. The company has been in existence for approximately 10 years. I have been with the company as their privacy officer for 6 years.
hmm All right, so I know you were with Johns Hopkins, correct?
I was previously with Johns Hopkins as the deputy privacy officer in the privacy office.
And you did that for a while? How
I
long
did
were you
that
there?
for approximately 9 years.
Uh-huh.
I was with Johns Hopkins for a total of 13 years, where I did some work related to contracting, purchase of medical
hmm
equipment and lab and um, pathology services, contracts and so forth.
All right. So that gives us a good understanding of your experience and what you're going to bring to the discussion today. You know about what's going on in health systems around this kind of stuff, as well as your experience with Protenus. So what we want to do today, to be super helpful to our readers and listeners, is we want to help them understand what's going on the privacy landscape. The privacy landscape changes, and then the people who follow us are the people dealing with the technology, and they have to deal with the changes that come about. And we're going to get into all of this, but for example, you have to share this, or you can't share this, or
Right.
this field or that field. All those changes in the law, the privacy laws, have to then be put into effect by the IT folks, right?
Right.
Because all this is technology, and some of that can be extremely hard. Some of that can be challenging. Some of that needs significant timelines. And we assume that the lawmakers understand this and give everyone plenty of time. There's a lot of costs involved. There's a lot of vendor dynamics involved because a lot
Yes.
of times it's not you yourself as the health system IT person doing this. It's making sure your vendor is up to speed and has a plan and all that kind of thing. So we'll get into lots of that. But
Okay.
let's start out. I want to start out with the idea that recently I did an interview, or it was a webinar, and the CIO on the call expressed a lot of frustration with all the differing privacy laws and how difficult it is to follow everything and stay on top of everything, be in compliance with everything. So let's talk about that dynamic. If
Okay.
you are a CIO of a health system, now a lot of these health systems now span multiple states. You could be in one state, you could be in multiple states, you could be in half the country. But you have to make sure you're in compliance, not just with the laws of the state you're in, but any state you're operating in, and then pretty much every state, right? Because you could have a patient come from California or Chicago, and I heard those are two places where the privacy laws are quite distinct and specific.
Right.
But what are your thoughts there on that frustration? And I know we're going to talk about some different things coming down the pike that might simplify this, but your thoughts on that dynamic of the frustration of trying to be a CIO and deal with a bunch of different laws in a bunch of different states.
Okay. So that frustration is shared by many, not just CIOs, but anyone who's working in healthcare compliance, whether it's from the security or privacy side. And there used to be the main law across the land was HIPAA. And then in the last, I'd say definitely the last 5 years, but prior to that, we saw many other laws passed, many other federal and state agencies getting involved in putting their stamp on what they think the privacy regulations should be. And anytime you have multiple regulations that are layered, you have complexities and confusion and increased costs to comply. Right now, obviously, we still have HIPAA and we have high tech, which are the federal laws. There is a push to pass a federal healthcare privacy law that would work with HIPAA, but would be a set standalone law. Right now, what's been introduced into Congress, it's known as the American Privacy Rights Act.
Mhm.
And it's not just healthcare, it's all privacy related laws. It's getting some pushback, as we fully expected. This has been attempted in the past and always failed. There was hope that this year it would be there would be more of an opportunity for it to be successful in Congress, because there was a bipartisan effort when the bill was introduced. However, it has not proceeded through committee. So, but we do have that law that's kind of hanging out, that proposed bill that's kind of hanging out there, that will change things on a federal level. But state level, we now have 19 states that have enacted privacy laws. Many of them are consumer-based laws, but they also weave their way into, some healthcare requirements. There are 6 other states that have pending bills. So you can see how many states have jumped on the bandwagon of passing their own regulations. You also have regulations by the FTC that we have to comply with.
Mhm.
You have CISA, which is the Cyber Security Infrastructure Agency, which has its own set of guidelines and regulations. So there's multiple levels. And at some point you stand back and you say, which one do I comply with? Or how do I comply with all of them? These layers of regulations. And that is frustrating. It is a challenge and it is expensive. And the question would be, how do you keep on top of all that? And it's not easy to do that. It's important to network with other healthcare organizations that may be following things a little more closely than possibly your organization can do. I know the American Hospital Association is very active in following these different regulations and laws, and even objecting to certain regulations and putting in formal written opinions and requests. And there was even a lawsuit filed by AHA against HHS. So there are agencies that are assisting with following these regulations, standing up for the healthcare profession. Chime is another agency that is very good at following and advocating for healthcare agencies that maybe you don't have the resources to follow all this yourself or make objections.
Mhm. Yeah, do you want to give any distinction between laws and regulations passed by agencies?
Yeah,
Those
that's
are technically different, right? Those are
yes.
different things,
And
and I think
yeah,
there's been some ruling recently that the agent it was the Chevron, is it the Chevron thing that
yeah,
the agencies basically got to take it easy,
right.
and something to that effect, like they're overstepping. But go ahead.
Yes, yes. So obviously a law is something that's enacted by a legislative body. And unless it's overturned, it's official.
Hmm.
The regulations are supposed to be by the various agencies that are tasked with enforcing those laws. And a regulation is supposed to say, this is the way you comply with the law. This is the way we as the agency and tasked with enforcing the law, this is how we see that everyone out there needs to comply with this law. The
Hmm.
problem is recently, some people view agencies as overstepping their bounds and actually passing their own laws,
Hmm.
going beyond what the agency objectives are supposed to be, which is enforcing already existing laws. And a regulation is supposed to guide you into how you are supposed to be in compliance with the law. The agencies are not supposed to be passing the laws. So there is a difference, and there has been pushback, as we've seen with the recent Supreme Court ruling. They want to rein in some of those agencies, particularly federal agencies. That's what that ruling was. But you probably see it just as much on the state level. You get on a roll with these agencies and they just keep going and going with the different levels of rules, regulations, laws, whatever you want to call them.
Mm-hmm. Mm-hmm.
And
And
that
go
makes
ahead.
things more complex,
Yeah.
because then you don't really know, well, the law says this, but now the agency says this. What am I supposed to do here?
Do you ever see regulations that are not sort of based on laws, meaning they really are not clarifying a law, it's just a new rule?
You know, there probably are. Off the top of my head,
Yeah.
I couldn't list one now, but I'm sure that the frustration and what led to this
Mhm.
objection on the Chevron ruling was just what you've stated. Agencies overstepping their bounds and actually trying to enact
Yeah.
laws as opposed to enforcing the laws that are
Or
already
clarifying,
or
right? Clarifying compliance with. I think that's what you were trying to say,
yeah,
right?
yeah.
Yeah.
This is how you comply with an
Right.
enacted law.
Right.
Right.
Let's talk about what people are obliged to comply with. So I don't know if my earlier example was correct, but let's say you're a health system, or you can use John Hopkins that operates in a certain state or a certain number of states, um, and you get a patient from California.
Mhm.
Are you under an obligation to comply with California state laws if you don't operate in California? You just happen to have a patient come who lives in California.
Okay. So if you are a California regulatory body, you're going to say yes. Okay. If you are probably a state of Maryland agency that does not operate in California, you're probably going to say no. Unfortunately, there is no clear answer to that, and hospitals and health systems have been left to make their own decision internally what their policies will be on that, because there are two different paths of thinking in that regard. If you have an organization that does business in only one state and the patients are coming to them, there's a colorable argument that you only have to comply with the state where you are operating. Those individuals are coming to you for care. The care is being given in that state. The medical records are residing in that state. And those are the state laws that comply. There's a colorable argument for that. But there's probably just as much an argument on the flip side, where if you are encouraging people to come to you for care,
Hmm.
but they live in another state, they are subject to their state's laws, and you should be complying with those laws as well. I don't know that there's a right answer, but I think what's important is an institution needs to make a decision, needs to have documented policies and procedures, and needs to be consistent with how they handle that question. The problem is if you say, I'm a very large academic medical center, and I'm pulling patients from not only all over the country, but all over the world, you might have a difficult argument with saying, I'm only going to comply with my state's laws, because you are enveloping
Hmm. Hmm.
all the country and
Hmm.
beyond. Um, it Most institutions have made the decision from the standpoint of, say, breach notification laws. Most institutions, I think, are leaning towards responding to whatever that patient's home state requires. Just to be on the safe side, that's what they do. So they would send a breach notification that complies with California law, as opposed to just Illinois law or New York law or Maryland law. But again, I think whatever decision an institution makes, you have to have it founded on sound decisions, be consistent, have
Hmm.
policies, and stand by your decision.
Yeah,
But I don't
it's
know that there's a right or a wrong there.
yeah, it's almost like what is reasonable, right? Let's if we're a health system or a hospital and we operate in one state, we're fairly small. I can't imagine I'm going to worry about what's going on in all 49 or the other 49 states,
Exactly.
right? But if I'm a large health system and I'm in 15, 20 states, well,
That's a
maybe,
different story.
right?
Right.
That could be a different story because now I probably have the bandwidth also to maybe follow these things. My team's big enough. So
Right.
I guess there's a reasonableness element to how you approach this.
Not only that, but if your institution has clinics in other states,
Hmm.
then clearly you're going to be subject to that state's laws because
Right.
you're operating within that state. The question I think is a little more clouded when you're only physically in one state,
Uh-huh.
all the care is being provided in one state, and all the records are maintained in one state. Then you might have more of an argument that you only have to comply with your state's laws. But again, there are individuals who disagree with that, and to be on the safe side, they would say wherever that patient's from, we're going to comply with that state's laws as well.
Okay, so if and again, I try and put myself in a position of a CIO or a CISO at a
Right.
health system. So I'm busy, I'm doing stuff day to day, and I probably have somebody who is heading up at the health system compliance and privacy, certainly legal. Who who is following all this stuff? I mean, what's how does the responsibility break down? Do I sit there as a technology executive and say, well, my privacy officer will bring things to my attention that
Mhm.
we need to be in compliance with, and then I will figure out how to do that. But I am not going to worry about deeply following privacy laws because it's not what I do. I do
Right.
technology. So I'm going to wait. I'm going to leverage or rely upon that person. And you can get into sort of the different roles and how they work together when we talk about legal privacy compliance.
Yeah.
What do you think's the best dynamic there? I don't think we can expect the technology executives to be deeply following privacy regulations,
I
right?
would agree with that.
Yeah.
I would agree with that. Your technology and security specialists better be up to date on the security requirements. That's their job. Okay. When it comes to privacy and other compliance components, you will be relying on others in your institution whose job it is to follow those regulations and laws. The complication comes into play because all of these laws are interconnecting in some fashion. And if you are a larger institution and you have a dedicated legal department, you should definitely have an open dialogue with someone in your legal department who is in the regulatory affairs um, sub-department, or has the responsibility to track new legislation. There should be an open dialogue and regular communications. And that's true for the privacy officials as well. Like, not all privacy officers monitor new regulations. If they have a large institution with a legal department, it's usually the legal department or the regulatory affairs department, which may be separate from legal, who is following all of that legislation. And that's their job. They follow local law, state, local, and federal laws, and then communicate out to the institution, this is new, this is what we need to do, let's talk about this. If you're a smaller organization, that's where it becomes more challenging. If you don't have a regulatory affairs office or a large legal department that is doing that for you, someone has to take responsibility for doing that. And that's going to be a dialogue amongst the different leaders, the executive team, the leadership team. Who's going to have the responsibility to monitor regulation, and who's going to have the responsibility to communicate out to the other leaders changes, new laws, changes to existing laws. It's a challenge, especially when we have so much happening in the legislative world now. Every day you read about a new guidance, a new regulation, a new proposed law that's being tracked through the legislative process. And then, when something gets passed, there's usually a rulemaking time period where you can make comments. There's an enforcement date that's out in the future at some point. Somebody needs to be tracking all of that. It's very complicated and it's time consuming. So in a smaller institution, you need to talk about whose job is this going to be? Because if you don't talk about it and you don't assign someone, nobody's going to do it.
I
Nobody's going to do it. Nobody has the time. Nobody has the staff or the resources. So it has to be a discussion, and it has to be part of somebody's KPIs, somebody's goals to do this. And it may not be the CIOs. It might be the privacy officers, or maybe they each take a piece of it, but somebody needs to be tracking that somehow. The other option is, and I know some institutions do this because they don't have the internal resources, they have outside counsel or an
mhm.
outside consultant. They hire a vendor who tracks legislation across the country, the states, the federal, and they pay a fee to do that, but they get regular reports, and then they can make the decision whether this applies to our institution or not, and how are we going to put this into play in our institution. So some health systems or hospitals or small practices have to rely on external resources.
It makes perfect sense. You're making excellent points. So it's almost like you have to, as we talked about earlier, you got to figure out based on your size and where you operate, what's reasonable and what your approach is going to be. You might do that using resources internally, that type of analysis and decision making, or you might bring in a third party to help you with that analysis and render an opinion, right? Based on what we do and where we operate, and
Exactly.
the laws, what do you think is reasonable? What do you recommend? And
Right.
then you talk about possibly that constant monitoring and a report being generated by a third party if you can't do that internally. Brilliant, absolutely makes sense. You have to realize how important this is, first off. You have to realize the implications, and man, you don't want any of those letters saying you're out of compliance and you're being
Yeah.
investigated, right? That's the last thing you want.
Right. But I will also say this: not every law or regulation applies to every institution's business operations. You have to look at that as well. Just because the federal government or the state government passes some regulation or new law doesn't mean it applies to you and what you're doing. You need to take a step back and read the regulation, read the law, and determine, is this geared toward what I'm doing and how I'm doing it? And sometimes you might need a little bit of assistance with that. So again, you might want to get an opinion from outside counsel. Does this law apply to my company? Um, this is probably more important for those business associates that are working with covered entities, the vendors like Protenus,
Hmm.
um, that sometimes regulations are passed and they don't necessarily apply to the type of work we're offering covered entities. And so the rush to change your internal processes and your policies and put more resources on things sometimes is misplaced. You have to take a step back and make sure you understand what the law says and what the regulation is geared towards, and make sure it applies to your business.
Yeah, you mentioned some regulations or laws that were passed that seem to generally deal with consumers, but may have implications or may affect health systems. So, as you said, that's going to require some analysis.
Yes.
And I just can't picture that being a good use of an IT professional's time
Oh,
because
absolutely
it's going to
not.
take a lot of time. And what does my opinion mean? I read
Yeah.
I don't even know how long these things are. It could be extremely long.
Oh, yeah.
So it's probably not a good use of their time. You know, you get someone who's an expert at these things to render an opinion
Yeah.
before you go forward, obviously, with making changes.
Yeah. And some of, as you said, some of these regulations are 300 pages, 600 pages, 1,000. I don't want to read. I
No,
don't want to read that. It's mind numbing.
right.
And most of it is not, like, you can cut half of it out and, like, I don't even need it. This is all the preamble and I don't need.
Mm-hmm. Mm-hmm.
Um, that's my opinion. I'm sure there are others that would say, no, you've got to read every word. Well, knock yourself out. That's not right. Um, but someone who's trained in technology and security and the things I'm not trained in, they don't necessarily understand rulemaking and legislative analysis and what a law or guidance
Hmm.
really means. And I wouldn't expect them to. And they're working with limited resources. So sometimes you have to spend a little bit of money to get the right opinion. And that's why I was saying sometimes you have to engage outside counsel to give you an opinion. Or if you're fortunate enough to have a regulatory affairs department or a legal department that's large enough that can do that for you, get a written opinion from them.
Absolutely great. I want to talk a little bit more about this communication that you mentioned between these key players in a health system. It seems to me to be absolutely critical. Again, we talked about sort of the progression is decide your strategy based on legal opinions and what you feel is reasonable in terms of what you need to be monitoring. How many states do we need to be monitoring? Obviously, all the federal agencies and whatnot. So
Right.
these are all the things we've decided we need to monitor. Now that's got to be assigned, as you mentioned, and I love the specificity you bring to understanding roles, because if it's everybody's role, it's nobody's role. So
Yeah.
whose role is it to monitor these things? Now that individual's monitoring these things may be a privacy expert, understanding regulations and legal, and be able to render an opinion, but they're not an IT expert, and therefore, if they don't share, if they don't share
Mhm.
with the IT executive, they may not share because they don't realize there's IT implications
Yes.
in right, in what they're looking at, so they don't share it, and then when it does finally get to the IT person, they say, "Oh my god, we're gonna have to do so many things differently. I wish I'd seen this earlier." Or, "No, we're good. This isn't an I there's no IT implications of this privacy change. We're good." So that's why that communication has to happen, because the person absorbing and analyzing is not an IT expert, right? So they need to
Exactly.
communicate.
Exactly. Like when I see a new regulation or enforcement action or law, and I read it and it gets into cybersecurity specificities or the security rules specificities, I consult with our CISO,
Mhm.
who is also our chief technology officer.
Mhm.
And we have a conversation about what does this mean? And I will share that portion of the written documentation so he can read it for himself. And many times he's like, "Yeah, we're good. We're already doing this." And I'm like, "Oh, well, see, I read it and I didn't
Right.
know because that's not my area of expertise."
Right.
Um, Now I've learned over the years, certain things that I can read and say, "Oh, I know we're doing that," because
Mhm.
I've been told by our CISO before, we're good.
Mhm.
But if I read something new, I'm like, no, I'm letting him know about this because I don't know.
Right.
And you have to be willing to say personally, I don't know,
Mhm.
and not be embarrassed by that because that is not my area of expertise. I was not trained in technology. And while I know some of the buzzwords and I understand what my company does and how we do it, that still doesn't make me the expert. So I have to be willing to share with the individual who
Right.
is the security expert or the IT expert and just not be embarrassed by that. That person doesn't have the same knowledge or background that I have
Yeah.
in interpreting the privacy regulations. So it's a fair trade-off.
And a great point. And you also don't want a situation sort of the reverse, which is a privacy expert or someone not not monitor or saying to themselves, "Well, I thought Mr. CISO or Mr. CI, I thought you were looking at this. I
Yeah,
didn't know. I thought you were monitoring this privacy stuff because this is an IT issue
yeah,
that is in the privacy thing. So I thought you had it. So that's why we need to communicate."
right. Oh, absolutely. Like as we know, the HIPAA laws have a privacy rule, a security rule, an enforcement rule, and then you have high tech. And some of that is security based. I look at it as a whole. So when there are proposals to change something in the security rule, I read that and understand it. But I share that with my CISO.
Mhm.
If it's just the privacy rule piece of it or the enforcement rule, I know that that's not his area of expertise and he doesn't have to worry about compliance with that.
Hmm.
But the security rule part really is his area of expertise and he has to comply with that. So although I make sure I understand it because I'm the HIPAA person at the company, I share that with him. Anything to do with cybersecurity changes, um, guidance that might change the way we are doing our
Hmm.
audits, that's his world. So I
And
share with him.
and when we're dealing with people that are essentially on the same level at the org chart, like a chief privacy officer and a chief information officer, I assume these are generally at the same level. Nobody's telling anyone what to do. Nobody's dictating. Nobody's ordering. It's a discussion and say, here's what we need to do. How
Yeah.
does this best get divvied up? Am I right that's the collaborative discussion approach as opposed
I
to
think that's true in a small organization like Protenus.
okay.
When you get into a mega
Hmm.
organization where you have large departments with big budgets and lots of staff, things may fall through the cracks. And that's why it's important, I think, that the leadership of those departments be the ones regularly meeting, regularly communicating, whether it's quarterly, twice a year, monthly, however they decide they need to do it. Those are the individuals that need to leave those lines of communication open and make sure that they're all on the same page about who's doing what, whose responsibility is what, whose KPIs are these,
Hmm.
um, because large organizations will get focused on what they're doing and
Hmm.
only what they're doing
Hmm.
and forget that there's this other world out here with multiple other departments. It's easier when you're smaller, I think, because you're all together
Yeah.
all the time.
Hmm.
In the large organizations, it's very departmentalized and that creates its own challenges. So that has to happen at the leadership level to be sure it filters down to everyone whose responsibility it will be to put into action these new regulations and requirements.
That's about all we had time for, Teresa. As a
Oh,
final
okay.
question, yeah, we're already at time. As a final question, I wanna ask you. I don't think anybody's taking this stuff lightly, right? I mean, it's not like, do you think we have to tell any of our IT executives like, hey, you got to pay attention to this? But
No,
as we've alluded to, maybe they think someone else is assuming, maybe they're assuming someone else is looking. They need to have these conversations. Your final piece of advice for the CIOs and the CISOs regarding privacy.
make sure you talk with your privacy officers, your legal departments, your regulatory affair departments, and with one another, because sometimes tech and security are separate departments. IT and security may be separate departments. So it's not just IT, it's the
Hmm.
security folks.
Hmm.
And you have to just, you have to communicate. You have to be talking, meeting, discussing, setting new policies, updating policies. If you don't have those lines of communication open, nothing will get done. And then either you will have an event that is devastating, or a regulator will visit, which is also devastating.
You don't want that letter from the OCR, right? Is that who would usually get the letter from?
It could
No?
be, well, it could be from the FTC, it could be
Uh,
from CISA, it could be from HHS, and it could be from a state agency,
you don't want any of those letters.
an attorney general's office. Yeah. Yeah, I've been on the receiving side of some, where not at Protenus, where I worked
Yeah.
before. And you deal with it. You just take a deep breath and you
Yeah.
deal with it. But yeah, if you can avoid it, that's the best course to take.
And I think that's the best piece of advice to leave us on today. Teresa, thank you so much for your time. I really
Oh,
appreciate it.
thank you for the opportunity. I appreciate it. Thank you.